Welcome to another outstanding City Club Forum. My name is Susan Kelly, president of the club. Today, we focus on civil liberties challenges in the 21st century, particularly in light of last September 11th. Our guest speaker is Nadine Strossen, professor of law at New York University and national president of the American Civil Liberties Union. This program is co-sponsored by the ACLU of Oregon. Today, we are welcoming a new group of Lincoln High School Constitution Team students as honorary members of City Club, and that is very, very much thanks to the law firm of Stoll Reeves, who sponsors these students. We're lucky to have, We're lucky to have a number of these students with us today, as well as a handful from last year who just couldn't stay away. And as you may have noticed last year, their questions are stellar, and we're looking forward to more good student questions today. Join us for our annual Back to School program next week, featuring 3 principals from Portland Public School District Number 1. They will talk about schools with spirit, schools with results. Our guest speakers will be Judy Bryant, principal of Humboldt Elementary, Sarah Taylor, who is principal of the Environmental Middle School, and Patricia Thompson. She is principal of Madison, and that, of course, is here at the Multnomah Athletic Club. Please pay very close attention to your bulletins in the coming weeks. I know I've said this before, but it's so important. They'll contain several board-approved resolutions on ballot measures that will be on the ballot in November. These resolutions are based on related research reports and club positions on these issues. In addition, we have 4 committees finishing their work on 5 of the measures that will be on the ballot. These reports will be coming to you for debate and voting in the next several weeks. On these days, we will begin the Friday forums at 12 noon in order to provide sufficient time for the report, the vote, and the speaker. You will notice in your bulletin exactly which days those are. I've already read 2 drafts of ballot measure 21 and 22, and they're excellent. I am very proud of our City Club committees. Anyone interested in obtaining a video of our program today, or an audio, or of any other City Club program, may do so through contacting Suzanne in the office, $20 for the video and $10 for the audio. Our City Club host seated at the head table is Corey Streisinger, a member of the program committee and a member of the board of directors of ACLU. She will have the privilege of asking the first question of our speaker, and following Corey's question, we'll accept questions from City Club members and ACLU members only. Please begin to line up at that microphone before Corey's even finished, so we have enough time for lots of good questions. Broadcast of City Club programs this quarter is made possible in part by the underwriting of Kaiser Permanente, Wells Fargo, and Zimmer Gunsel Frasca. We're very grateful for their support. Just a week ago, it was reported in the Tribune that a police officer brought home boxes and boxes of intelligence files in the early 80s, files that he had helped to compile and didn't want to destroy. These records were discovered on organizations like Physicians for Social Responsibility and Ecumenical Ministries of Oregon, and they're hardly subversive groups. Our mayor was photographed at a grape boycott. My mother's file is probably in there, too, for her anti-war activities. Yesterday, our City Council voted on a renewal of the Joint Terrorism Task Force relationship with the FBI. Contentious testimony lasted over 4 hours. Our very own David Fidenkwe, our Executive Director of American Civil Liberties Union of Oregon, is quoted in the paper this morning that without meaningful oversight of police actions, the city is doomed to repeat errors of the past. He urged the city to step out front, seek stronger oversight for its terrorism task force, and ensure all federal intelligence files are no longer active be purged. So our speaker today is very, very timely. Nadine was raised in Minneapolis and attended Harvard, was Phi Beta Kappa from Harvard in 1972 and magna cum laude from Harvard Law School in 1975. She is a professor of law at New York University, as I mentioned, and has been the president of ACLU since 1991. The National Law Journal has twice named Strossen one of the 100 most influential lawyers in America. In 1996, Working Woman magazine listed her among the 350 women who changed the world from 76 to 96. That's pretty outstanding. Since becoming ACLU president, Strossen has made more than 200 public presentations per year before diverse audiences. Her writings have been published in many scholarly and general interest publications, approximately 250, and I have the whole list here if anybody wants to look it over. She's co-authored a book called Speaking of Race, Speaking of Sex, Hate Speech, Civil Rights, and Civil Liberties, and she has authored the book Defending Pornography, Free Speech, Sex, and the Fight for Women's Rights. This is a very, very serious topic, and we have a very, very informed teacher or lecturer here today. However, the good news is there's a sense of humor behind her. I have it on authority from her co-workers that this was a little song that they wrote for Nadine last year. Defending pornography, fighting for women's rights. If you want to learn of liberty from the depths of up to the heights, go ask Nadine. She'll explain the fights. In a war on civil liberty by the strong powers that be, violating individuals with excessive authority, go ask Nadine about what she sees. When she's in the spotlight, we get a strong one-woman show, and at every opportunity, she will speak with gusto. Go ask Nadine, and I think she'll know. When logic is abandoned by our critics on the right, and the government is oppressive with its overwhelming might, go ask Nadine to lead the fight, lead the fight, lead the fight.
Thank you so much, Susan. That was one of the most unusual and interesting introductions I've ever had. I only wish you had sung it. Led the audience. I am so delighted to be back here in Portland before this impressive forum. I have very positive memories of my last visit here 5 years ago. And I also have very positive associations with this city in terms of crucial civil liberties issue, not including what was mentioned in the introduction, but we will look at the positive, right? On some front burner issues of national importance, indeed international importance, my ACLU colleagues here in Portland have collaborated with key government officials to promote both individual freedom and community well-being. I'd like to mention just 3 of them. The first is especially pertinent right now, since tomorrow is the beginning of Banned Books Week, an annual celebration of the freedom to read. So the first collaboration of national and international significance that starts right here in this city is the ACLU's latest effort to protect the unparalleled potential of the internet as, quote, the most participatory mass marketplace of ideas the world has ever known, close quote. And I am quoting a judge in one of the ACLU's cases that have successfully challenged a series of federal laws that would stifle cyber speech. The latest federal cyber censorship law is the badly misnamed Children's Internet Protection Act, or CIPA. And I say it's badly misnamed because it protects neither children nor the internet. To the contrary, it harms both by denying access to important, constitutionally protected information and ideas that are essential for education and the future opportunities of our nation's young people. I just think these wonderful young constitutional advocates, for example, from Lincoln High School, I know from past experience would be barred. Important information on key constitutional issues, including, ironically, issues of First Amendment censorship, if CIPA actually went into effect. Worse yet, CIPA's adverse impact goes far beyond young people and extends to all adults as well. As I'm sure you all know, what it literally does is to require all public libraries that get federal subsidies for their online services, which is essentially all public libraries, to install blocking software on all computer terminals with internet access. The ACLU promptly challenged this law along with the American Library Association, individual libraries, library patrons, and web publishers. We won a stunning victory last May by a unanimous vote of the 3-judge panel. The government has now appealed to the United States Supreme Court, and I believe the court is going to forbid the government to enforce this speech suppressive law, as it has done in our 3 previous cyber censorship cases. I'm delighted personally, and I know that all Oregonians are proud, that this landmark case will go down in history under the name of our lead plaintiff, the Multnomah County Public Library. And on behalf of everyone who benefits from the internet free speech worldwide, I would like to thank the library as well as the County Commission and Library Director Ginny Cooper for their leadership in this important lawsuit, and also in constructive efforts to keep the internet both safe and free for all. Now, that very same dual goal, safe and free, has fueled the ACLU's monumental efforts since last year's horrific terrorist attacks, which struck the majestic Twin Towers just blocks from our national headquarters. Again, as with our online efforts, this campaign has global significance. And again, key aspects of this campaign have been waged right here in Portland. Last November, when the Justice Department launched dragnet interrogations of thousands of young Muslim men based only on national origin, your assistant police chief, Andrew Kirkland, refused to succumb to federal pressure. He earned worldwide attention. I'm sure you saw it from here, but let me tell you, I saw it from the other coast and also from other countries. He literally earned worldwide attention for his conscientious refusal to engage in ethnic or religious profiling or to violate freedoms of speech, religion, and association. And this courageous stance inspired other local police departments in a number of cities, in a number of states around the country to follow suit. Significantly, Chief Kirkland's position was also based on a unique Oregon statute, which should also be a model for the rest of the country. It prohibits law enforcement agents from gathering information on the political, religious, or social views or activities of any person or group unless they are suspected of criminal activity. I'm so proud that this 1981 law reflects the advocacy efforts of my ACLU colleagues here, and I wouldn't be surprised from what I've learned about the City Club if the City Club did not also have some involvement. But I know my ACLU colleagues worked very hard to push this through in response to information that the Portland police had been maintaining files on people just on the basis of their beliefs. And as we know, these are issues that are still very much with us. I look forward to working with Oregonians to persuade the United States Congress to adopt the very same kind of law. We need it now more than ever to counter Attorney General Ashcroft's new FBI guidelines, which expressly allow and authorize and encourage surveillance and infiltration of political and religious gatherings without even a scintilla of a suspicion of any criminal activity. Even such a conservative Republican and government supporter as Wisconsin Congressman James Sensenbrenner has condemned these guidelines for, quote, going back to the bad old days when the FBI was spying on people like Martin Luther King, close quote. Critics of John Ashcroft's new guidelines even include some leading religious conservatives who actually had campaigned for his appointment as Attorney General because they agree with him on other issues, such as abortion. Examples include Ken Connor, who's president of the Family Research Council, and Grover Norquist, who is president of Americans for Tax Reform. As Ken Connor put it, quote, "We religious conservatives need to ask ourselves, how would our groups fare under these new rules?" Now, speaking of the United States Attorney General in the same breath as your fair state, brings to mind, I'd say it brings to all of our minds, yet another recent development here in Oregon, also of worldwide interest, namely the decision last spring by federal judge Robert E. Jones in a case with a very powerful name. The case is called State of Oregon versus John Ashcroft. In forceful language, Judge Jones struck down the Attorney General's high-handed unilateral attempt to override the will of the people here by threatening federal action against doctors who dare to comply with Oregon's own law, the Death with Dignity Act. In repudiating the Attorney General's actions, Judge Jones struck an important blow not only for individual freedom of choice, but also for democratic governance, particularly at the state and local level. I'd like to share with you just one key passage from Judge Jones' opinion. He wrote, Ashcroft essentially nullified the Oregon Act and 4 years of Oregon experience in implementing it, an unwarranted and unauthorized intrusion into the sovereign interests of Oregon, the medical practices of Oregon physicians, and the end-of-life decisions made by terminally ill Oregonians. The Attorney General's high-handed tactics in this Oregon case to fight the war on drugs are strikingly similar to the same high-handed tactics he's been using nationally to fight the war on terrorism. Just as John Ashcroft sought unilaterally to override your state law, so too he has sought to do the very same with a very important federal law, namely the United States Constitution. Ashcroft has issued a series of regulations and other measures without even consulting Congress that also violate precious individual rights as well as key structural principles in our constitutional democracy. In the Oregon case, Ashcroft acted contrary to our system of federalism, which divides power between the national and state governments, and that was especially ironic for someone who's claimed to be a champion of states' rights. In the national counterterrorism campaign, Ashcroft has repeatedly violated the system of checks and balances, which divides power among the 3 branches of the federal government. Not only has he refused to consult with Congress before asserting sweeping new powers, he also has refused to respond to congressional requests for information about how the government has exercised and is exercising every day these far-reaching new powers. He thus has thwarted Congress's essential oversight role under the Constitution. This has outraged even such a stalwart conservative Republican as Wisconsin Congressman James Sensenbrenner, who is, among other things, chair of the House Judiciary Committee. Sensenbrenner even has threatened to take the extraordinary step of serving a subpoena on the Attorney General. That's how desperate he's getting. And the Attorney General has been equally disdainful of the 3rd branch of our national government, the judiciary. The courts should have an especially important role in upholding the rights that the Justice Department, how ironic that name is, the Justice Department now endangers. Through sweeping new powers it has bestowed upon itself. Yet the Justice Department is now bypassing judicial review in many key areas, arrogating to itself the power to decide everything from which deportation hearings should be closed to the public, to which attorney-client conversations can be intercepted by the government, to which defendants should be tried in secret military tribunals. I want to reiterate that the ACLU's mantra for our post-September 11th world is safe and free. The government's enormous inroads on such bedrock constitutional principles that undergird our free democracy are not necessary to keep us safe. These are unnecessary, unwarranted, unjustified infringements on personal liberty in the asserted but not actual goal of furthering national security. And this point, I'm saying it is actually the goal, but the measures are not actually necessary or even effective for accomplishing that goal. And that point has been stressed by national security experts as well as civil libertarians. Indeed, President Bush himself stressed our country's proud constitutional heritage in his first words to our stricken nation after the terrorist attacks. And believe me, those words, hearing them when I did, where I did, blocks from ground zero, those words are burned in my brain. I was thrilled as a civil libertarian and as a patriotic American to hear the president use that grave occasion when the world was hanging on every word to hail this country as the brightest beacon for freedom and opportunity in the world. He then vowed, no one will keep that light from shining. Well, I want to tell you, ever since then, the ACLU has been working overtime to help the president keep that vow. It would be tragic, obviously, if we let the terrorists terrorize us into abandoning those very ideals that they themselves attacked. To be sure, along with the Supreme Court, civil libertarians recognize that no right is absolute. But along with civil libertarians, the Supreme Court also has always recognized that before government may restrict any right, it bears the burden of proof. And it is an appropriately heavy burden of proof because there is a presumption in favor of freedom in our constitutional system. So to overcome that presumption, government must show that the restriction is actually effective in promoting an important countervailing concern, such as national security, and that the measure is narrowly tailored to do this. To be sure, in fairness, I always point out that many post-September 11th measures do satisfy this basic constitutional standard. They do, in a nutshell, maximize security with minimal costs to liberty. That's true, for instance, of many aviation security measures. These are particularly dear to my heart as a super frequent flyer. But in seriousness, the ACLU has been advocating these kinds of measures for years as not only less invasive of freedom than alternatives that are proposed, such as engaging in unwarranted surveillance or profiling activities, but also more effective. Fortifying cockpit doors, a measure long overdue. The same thing with increasing the Sky Marshal program. The same thing with respect to enhanced screening and supervision of security personnel. And let's not forget luggage matching with passengers, which still isn't in effect more than a year after the terrorist attacks. That in one fell swoop would, I think, do far more real for national security than the many unnecessary invasions of individual liberty. And unfortunately, too many post-September 11th measures have been the worst of both worlds. They do demonstrably violate our freedoms, but they do not demonstrably enhance our safety. For an excellent overview of the many recent assaults on our rights, I commend the ACLU's new report, Civil Liberties After 9/11, the ACLU Defends Freedom, and you see we are waving the flag and the values for which it stands. It's available on our website, which is also a treasure trove of information about all the post-September 11th threats to liberties. These are so numerous that I don't even have time to list them all now. Everything from secret military tribunals that have been denounced even by conservative national security hawks as, quote, kangaroo courts, to secret arrests, trials, and deportations, which federal judges have decried unanimously in our lawsuits against these secret proceedings as, quote, odious to a democracy. For details about all of these unwarranted intrusions on our precious freedoms, including what you can do to help us counter them, please visit our website at www.aclu.org. I've gotten compliments on it from journalists, teachers, lawyers, interested citizens from all walks of life and all political perspectives from all over the world as the most comprehensive database about all of these issues. Now, as I said, too many of the post-September 11th measures that do make us less free, do not make us more safe, according to security experts. For example, a remarkable article in the Washington Post last year quoted 8 former top FBI officials on the record criticizing the government's use of mass dragnet interrogations, arrests, and incarcerations, saying this was not the effective way to gather intelligence to protect us against future attacks. One such critic who speaks with special credibility is Judge William Webster, who was the director of both the FBI and the CIA under Presidents Reagan and Bush Sr. Based on his own extensive experience, Judge Webster has strongly criticized the pervasive new surveillance measures that are now in place. He said, from 1981 to 2000, the FBI prevented more than 130 terrorist attacks. We used good investigative techniques and lawful techniques. We did it without all the suggestions that we're going to jump all over people's private lives. We don't need to go in that direction. Other post-September 11th policies that have been criticized specifically from a national security perspective by national security experts include the infamous military tribunal order, which prompted even U.S. allies to say that they would not extradite suspected terrorists for trial or interrogation here. The over-reliance on religious and ethnic profiling, which according to intelligence experts not only targets too many innocent people, but also misses too many dangerous ones, since al-Qaeda will simply deploy operatives who elude our profiles. Another case in point, the secret arrests, incarcerations, trials, and deportations of at least 1,200 people, mostly young Muslim men, not a single one of whom has been charged with a terrorist crime. And according to discovery information we've gotten in our lawsuit seeking to enforce First Amendment and due process rights in these cases, the government has acknowledged that it doesn't even have any basis to believe that these individuals even have any information about terrorism, let alone involvement with it. And yet, they are still being, quote, detained, close quote, a euphemism for secret prisoners. And law enforcement officials, along with civil libertarians, have denounced these tactics because they say they undermine relationships with the very communities that we need to cultivate as sources, potential sources of information. One final example is the notorious TIPS program, an acronym for the Terrorist Information Prevention System, which seeks to turn everyone from Mr. Postman to the cable guy into snoops on their fellow citizens, and which would make it even harder for government officials to follow through on plausible, important leads from field agents, such as the failures that were so devastatingly documented last spring by whistleblower FBI agent Colleen Rowley. As one critic put it, under the TIPS program, we will be looking for terrorist needles in government-created haystacks. And that very same critique, if you think about it for a minute, really is a metaphor for so many of the government's post-September 11th measures, including its sweeping new surveillance powers. So many of these measures are overly broad dragnets, fishing expeditions, and therefore they are doubly flawed. They both sweep in too many innocent people, and they make it harder to hone in on the dangerous ones, determined not by who they are, but by how they act. In fairness, and I do strive very hard as the head of a nonpartisan organization to really be fair, so I do want to credit the administration for having trimmed back a couple of these unjustified measures in response to public criticism. Specifically, both the TIPS program and the military tribunals have been modified to reduce some of their most serious rights violations in response to the storm of criticism that greeted their initial announcements. Having said that, I will also note that even in their modified forms, both still flunk the basic constitutional test. They do not maximize national security with minimal cost to liberty, but I think they're an important instance of how we, by raising our voices and criticism, can have some positive impact on these policies. Just as many current counterterrorism measures have been criticized by leading law enforcement experts as well as civil libertarians, many likewise have been condemned by respected conservatives as well as liberals. Our political allies in preserving safety and freedom have included not only leading liberal Democrats such as Wisconsin Senator Russ Feingold, who waged a lonely, courageous Senate battle against the new federal anti-terrorism law, the only member of the entire United States Senate who voted against that law. And you know what? He was also the only member of that entire body who resisted a motion to pass it by unanimous consent. One vote for 1 hour of debate before passing a 400-page law. He does deserve a profile and courage. And interestingly enough, on the other side of the aisle, on the other side of Congress, it was a number, the opponents of the USA Patriot Act, who fought very hard and long and collaborated with the ACLU, included not only leading liberal Democrats on the House side, but I also want to single out there arch conservative Republicans. I've mentioned the chair of the House Judiciary Committee, Jim Sensenbrenner, also from Wisconsin, House Majority Leader Dick Armey from Texas, who actually walked over from the House to the Senate to cheer on Russ Feingold when Feingold was waging his lonely one-person debate against the USA Patriot Act. And another ally for civil liberties here has been Georgia Congressman Bob Barr. When Attorney General Ashcroft first tried to stampede Congress into rushing through his so-called anti-terrorism law last fall without any hearings or any debate at all, Bob Barr led the resistance. He's a former U.S. attorney and CIA official with a solid, tough-on-crime record. Specifically in light of that expertise, he questioned the administration's pressure to push through the new law. As he noted, quote, "The Department of Justice has sought many of these authorities on numerous other occasions, has been unsuccessful in obtaining them, and now seeks to take advantage of what is obviously an emergency situation." It was in light of these facts recited by Bob Barr that I referred to the new law as the so-called anti-terrorism law. So-called because most of its intrusive, expansive new powers would apply to all criminal law enforcement, not only to terrorist or violent crimes. Worse yet, the law empowers the government to spy on the communications and transactions of completely innocent citizens who aren't even suspected of any wrongdoing at all. Now, as you know, the law's proponents concocted an unwieldy name for it, designed to generate the acronym USA Patriot Act, and I wonder if even our crackerjack high school constitutional experts know what that stands for. And if you in the audience do not know what it stands for, you're in very good company. Most of us do not know what it literally stands for, but we do know what it actually signifies, that you sure are not a patriot if you dare to question or criticize this law. John Ashcroft went so far as to insinuate that critics are not only unpatriotic, but worse yet, traitors. In his testimony before the Senate Judiciary Committee last December, Ashcroft attacked those of us who raise what he dismissed as phantoms of lost liberty, and I say us advisedly because I had the honor of testifying before that same committee 2 days before. Echoing the Constitution's definition of treason, Ashcroft said that criticism by freedom-loving Americans, quote, only aids terrorists and gives ammunition to America's enemies. But I can't help thinking of Thomas Jefferson's insight that dissent is the highest form of patriotism. In other words, daring to do your civic duty, something that all members of this fine club are conscious of, your civic duty of paying attention to what your government is doing in your name and calling attention to what you consider to be misguided, immoral, unconstitutional government policies. So my heroes and heroines of our post-September 11th world include not only the justly celebrated firefighters and others who fought to preserve human life, but also the past and present government and law enforcement officials who have fought to preserve human rights by daring to resist the USA Patriot Act and other government policies despite the extraordinary, unprecedented political pressure they faced. As I've stressed, these critics span every spectrum, including the many diverse individuals I've already mentioned, one of whom is Portland's own Assistant Police Chief Andrew Kirkland. He, to me, along with Russ Feingold, Colleen Rowley, Bill Webster, to mention a few, all deserve profiles and our profiles and courage. After all, it's not surprising when you think about it that these people are so ideologically diverse, because holding our government accountable to constitutional standards is a core traditional American value. I know that phrase, traditional American values, has somewhat of a different connotation here in Oregon, given some of the past anti-gay rights campaigns that have tried to seize that concept, but we should seize that term. We stand for core traditional American values of freedom and justice and equality and dignity for all. And that's why the ACLU has always been staunchly nonpartisan. Right after the terrorist attacks, we spearheaded an extraordinarily broad, diverse coalition of approximately 180 concerned citizens groups. Just 9 days after the terrorist attacks, exactly 1 year ago today, September 20th, 2001, we held a press club conference at the National Press Club in Washington, D.C., to release our joint statement called In Defense of Freedom at a Time of Crisis. And I don't know how things were here in Portland at the time, but in Washington and New York, there was still a state of chaos and a real sense of present crisis, not potential crisis. So as I think back to those dark, dark days a year ago, to me it is almost unbelievably remarkable that we could have so quickly, under those conditions, trying, as psychologically trying as they were physically trying, that we could assemble such an unprecedentedly broad, diverse, large coalition in such a short period of time. And these groups were from all across the political, religious, and ethnic spectrums. On the political spectrum, to give you just some sampling, from such ultra-liberal groups as Americans for Democratic Action to such ultra-conservative groups as Phyllis Schlafly's Eagle Forum, figure that, and everything in between. And I shouldn't put it in the past tense because we are still working in coalition with all of these groups to stand up for core traditional American values that are being violated by our government now. A poll that was released last week, a year after the terrorist attacks, showed that most Americans believe that the average person has given up some rights since September 11th. Quite inconsistently, though, only 21% of these same respondents believe that they themselves have given up some rights. I suppose that the poll respondents, like many of us, are living in our own version of Garrison Keillor's Lake Wobegon, where we're all above average. I wish this wishful thinking were correct. Unfortunately, though, the post-September 11th measures have undermined precious rights of everyone in this country. Given that reality, I wish that more people would understand the high personal price that they themselves are paying in terms of their own freedom, and also that they're being overcharged since these sacrifices aren't necessary to advance security. And I'm going to truncate my remarks because I want to have plenty of time for questions. But in a nutshell, I think most people do not realize that the government now has sweeping new power simply to get records about you and your personal transactions, about what you would logically and fairly consider to be your most intimate personal activities, such as what books you look at, check out in a library, what books you buy in a bookstore, what web surfing you do, what your medical records are, your financial transactions. All of these documents can now be obtained by the government simply by asserting that they might be relevant to a terrorism investigation. And I'm not surprised that people don't know that their rights are being violated, and this is not theoretical. Surveys have been done. Something like 10% of the libraries that were surveyed last February admitted on the record that they had given over patron records to government officials, and this was self-reporting, so it's only the tip of the iceberg. I'm not surprised you don't know that this is happening, because not only does the USA Patriot Act allow the government to violate your privacy by forcing institutions from libraries to hospitals to universities and everything else to turn over your records wholesale, but to add insult to injury, it then imposes a gag order on those institutions and prohibits them from telling anyone, including you, that your most private personal records have been turned over. So we really have to make people understand that they themselves have sacrificed. And the one issue in the poll where people did understand that their rights are being violated in large numbers had to do with freedom of information. 73% of respondents said that the government is not telling them everything they need to know about the war on terrorism. And even more significantly, 100% of the judges who have ruled on the administration's sweeping new secrecy policies have concluded that they violate fundamental First Amendment rights. And 100% of these judges have concurred that this secrecy is not needed for security. I'm so proud of the leading role the ACLU has taken in all of these cases. You've all heard, I think, about the most famous, which was rendered on August 26th by the highest court in the country to rule on one of these lately, and that was Judge Damon Keith, writing for a unanimous panel of the Sixth Circuit Court of Appeals in Cincinnati, striking down the government's routine blanket closure of deportation cases in language that has really echoed around the world. He said, "Democracy dies behind closed doors." I'm out of time now because I really want to hear your questions and comments, and I want to end with something positive. As that great philosopher Woody Allen once said near the end of a talk, I want to end with something positive, but I can't think of anything positive. Would you settle for 2 negatives? Well, I really do have many positive things to say. You can't be an activist unless you're an optimist. As I've noted throughout my talk, a wide array of people in this country have been vigilant and vocal in resisting the government's unwarranted invasions of our freedoms. This citizen activism has been effective in important ways, from prompting members of Congress to take constructive actions, such as oversight hearings, to prompting the administration itself to revise a couple of its own actions, as I described. So I would like to close on that note of public engagement and activism, urging participants in this important forum, in this important organization, to raise your voices, which are especially influential. After all, this is called for by the City Club's own impressive mission statement, which I was delighted to read. And for those of you who have not yet committed it to memory, let me refresh your recollection about your mission statement. I'm sure Susan could stand up and sing it, but to inform its members and the community in public matters and to arouse in them a realization of the obligations of citizenship. So I hope I have aroused all of you to exercise your civic obligation to speak out on these crucially important issues. As my favorite ACLU t-shirt proclaims, you have the right not to remain silent. And in these troubled times, I have to amend that slightly and specifically respond to John Ashcroft's notorious testimony last December. You have the patriotic duty not to remain silent. Thank you very much.
Well, Nadine, on behalf of the City Club and the ACLU, I really want to thank you for that inspiring speech. And I understand the ACLU has materials in the corner near the door. And my question for you is this. In times of crisis, this country seems to have the habit of reacting by cracking down on civil liberties. And well after the fact, we may regret it and realize that it was offensive and odious. The Japanese internment leaps immediately to mind. But then when the next crisis comes along, we repeat the cycle. What advice do you have for how to break out of that cycle?
That is exactly the right question, and I loved the letter that my colleague David Fidanki wrote to the Portland City Council about the issue that you're facing right here now on the Joint Anti-Terrorism Task Force. I'll have to do a paraphrase, but he ended that letter by saying, isn't it time that instead of looking back and apologizing for the mistakes that we made, we do the right thing now, that we learn from history? And I am encouraged, Corey, for this reason. I am particularly encouraged about the wide outpouring of criticism across the political spectrum. This is something that distinguishes this situation from that of the Japanese Americans. There's a wonderful collection that was put out called It's a Free Country, a book that I'm sure you can also get through the local ACLU. Andrew Kirkland was one of the contributors to it. Another contributor whose essay I recently read because he has an Oregon connection, he was born in Oregon, was Paul Simon, former senator from Illinois. And he talked about his boyhood memories in Oregon of the internment of Japanese Americans and how lonely his father was as the only critic in his community. And on a national level, there just were not enough critics. Indeed, many members of the ACLU National Board were not as critical of the president's position on those issues as they should have been. And certainly the United States Supreme Court completely capitulated. By the way, I have to say the ACLU in the West Coast did represent both Gordon Hirabayashi and Fred Korematsu, but we were denounced as being unpatriotic. I don't think, aside from John Ashcroft, critics of the government are being denounced in that way now, and the courts are stepping forward in a way that they never did in the past, and on an edifice of constitutional rights jurisprudence that, in fairness, did not exist in World War II. Not that I think that the Korematsu decision was in any way justified even by existing precedents, but for those of us who are familiar with constitutional history, at that time, racial apartheid was still legal. The United States Supreme Court had never held that the Constitution prohibits racial discrimination or racial segregation. Likewise, the United States Supreme Court in that era had not given any meaningful protection to freedom of speech. Now, the Supreme Court could go the wrong way, but if it did so, it would have to overturn decades and decades of constitutional precedents. I'm hopeful it won't do that.
Lily Mandel, City Club member. Since Oregon state laws protecting its citizens' civil rights provide more protection than federal laws, what is your opinion about the Portland Police Bureau becoming a member of the FBI Joint Terrorism Task Force that does not have Oregon's safeguards?
I agree with your statement, and I have, because I think that was a rhetorical question, and I have, no, that's fine, and I agree, and I have carefully read the letter and which I know was supported not only by the ACLU, but other organizations in this city. I think that it's especially ironic for a federal government that pays fealty to the notion of states' rights to trample on local authority and local autonomy. And my view has always been, both in my capacity as a constitutional scholar and as ACLU president, that one of the wonderful aspects of our constitutional system is that it divides and separates powers so that no one unit of government can put a ceiling over our rights. All the United States Supreme Court can do is put a floor under them, but it does not stop other units of government, such as local government or state government, from choosing to protect more rights than the federal government does. So please keep relying on local law that is more protective of rights, but don't stop there. Help us to enact those same rights protective laws in other states, in other cities, and last but not least, at the national level of government.
Need a bigger binder clip. Jim Harris, City Club member. 9/11 has been widely characterized as an intelligence failure. In your view, what specific minimal actions by intelligence agencies would have prevented this failure? And what are the implications of those actions for civil liberties and enabling legislation?
I do not at all hold myself out as an expert on intelligence. That's not my area of expertise. Unfortunately, it does not appear to have been the area of expertise of too many people in the CIA. And again, and here you'll note I was very careful to quote law enforcement and national security experts themselves. To me, Exhibit A, who has really not gotten nearly the attention she should have, was Colleen Rowley. If any of you have not yet read her letter, which Time magazine has posted online and calls it the bombshell letter, I urge you to do that in heartbreaking detail. She outlines how there clearly was probable cause, even the most ardent civil libertarian would say that, to have searched the computer of Zacarias Moussaoui, which could well have led to information that could well have staved off some of those catastrophes. And what's particularly heartbreaking and infuriating is the pattern of bureaucratic stalemate that she describes in Washington that you know had to have been replicated not only in that incident but in many others. So I think that it's impossible to say that we could have prevented this catastrophe, but I want to remind people, because again, this is something that I don't think has gotten nearly as much attention as it should have. After Colleen Rowley testified in Congress last spring, FBI Director Robert Mueller had a press conference at which he delivered an extraordinary mea culpa. He came very close to saying we might well have averted the September 11th catastrophe. He apologized in very strong terms. And the reason we forgot all of this was the very next day, John Ashcroft had a press conference in which he announced the new FBI guidelines that increase the surveillance power over people not even suspected of any crime at all. Now, this sequence is very odd when you think about it. And here I'm going to quote not only the ACLU, but New York Times columnist William Safire, conservative Republican who has been on the administration's case on all of these issues. He said that those guidelines were nothing but, his trademark alliteration, posterior covering pretense. That basically John Ashcroft stood up there and implicated, well, the reason for this catastrophe was that we didn't have those old guidelines that stopped us from snooping on you when you're in political meetings and when you're in church. And Safire said it is nothing but a smokescreen. The new power, arrogation of new power, is nothing but a smokescreen to hide the fact that they did not effectively exercise the previous power.
Chris Smith, club member. Even with Mr. Ashcroft's intrusions, we still govern in this country with the consent of the governed, which is why I was particularly alarmed this morning to hear a piece on NPR that reported polling that 49% of Americans feel that the First Amendment is too strong. Mm-hmm. Could you comment on public sentiment about civil rights following 9/11?
I heard that interview with my friend Ken Paulson of the First Amendment Freedom Forum, which for years now has been doing these annual surveys. And it prompts me to ask a question of our high school constitutional experts, because right after he reported the survey finding that 49% of people polled thought that the First Amendment goes too far. He next reported that only 1% of the people polled could say what the First Amendment is. So It's a challenge, but I think so. Taking the one statistic in isolation is perhaps a little bit sensationalistic, especially when you and I don't at all. Believe me, I spend my whole time public speaking on colleges and university and law school campuses and other forums, precisely because I do want to spread not only the knowledge in a passive sense, but more importantly, the commitment in an activist and engaged sense. And I think the basic lesson is that people feel very strongly if their own right to speak is in danger, and that's why it's so important to get the message out. It's not only those anti-war protesters that you disagree with, or pro-war protesters, as the case might be. You have to explain to the person that what is at stake is your right to express your opinion.
Roy Clark, City Club. I'd like to congratulate you on your use of humor. It's one terrific weapon to strike these people down, in my opinion. But apart from that, let's see what we can find humorous in this. I was born in Europe a long time ago, and although there are people here older than I, we do remember the rise of Nazi Germany, the 30s in Germany and Europe, and I see frightfully chilling parallels between that period and the period we are now undergoing. I do hope that it isn't the same song, second verse, and I do hope we can find some humor to turn that around. Thank you.
Well, thank you very much for that. I've read a lot about historical comparisons for many reasons, one of which is that my father was born in Germany in 1922 and came to this country only when he was liberated by Americans from the Buchenwald concentration camp. So, every time I speak to a military audience, which, by the way, is often, I always say that I literally owe not only my liberty, but my life to them because my father was scheduled one day before he was liberated by American troops. He was scheduled to be sterilized. So, I really do believe in our military forces. The parallel is often asked to me in a somewhat different context, and that is when the ACLU defends freedom of speech, even for hate speech, even for anti-Semitic speech. I'm often given another twist on the history in Germany. Oh, but they had free speech in Weimar Germany, and that helped Hitler to come to power. But as you know, one of the problems there was that there was not a strong constitutional democracy that did not strongly protect freedom of speech. And it was the critics of Nazism who were stifled, and the Nazi thugs who were not only spreading pernicious ideas, but who were actually engaging in violence on the streets that were unchecked by the government. So fortunately, I don't think that we are anywhere close to that degree of either unchecked violence in the name of any political ideology or the name of any cause, and we still have a much more robust freedom of speech.
Excuse me, just a moment. We're running out of time, but Nadine has agreed to stay. So all of you that can, please do stay, and we'll keep on with the questions, but our TV coverage will close off in a few minutes. And if there are board members, I know there are board members here today, Nancy's asked that we convene once the program's over up here by the podium for a quick little conference on the research reports. So go ahead, please.
Ruth Curry, City Club and ACLU member. Thank you for your comments on the dilemma we're facing and the fact that there is some bipartisan opposition. But since you're interested in women's issues, I wonder if you would address briefly the problems with CEDAW and the opposition of Congress, and perhaps explain CEDAW to the audience.
Well, it's one of the many international human rights treaties that this country refuses to ratify, the Convention for the Elimination of Discrimination Against Women. And I think one has to put it in a larger context. It's not just that we refuse to subscribe to international human rights standards that would protect the rights of women. We refuse to subscribe to international human rights standards that would protect the freedom and rights of everyone. There is only one other country in the entire world that has refused to ratify the Convention on the Rights of the Child. And that other country, it's one of the, I'm forgetting the name of it now, but it's an African country that is in such a state of revolution that it's not capable of ratification. So we're the only country in the world capable of ratification that hasn't done it. And I think the reason here is it's an arrogance, it's a double standard that we do not have to adhere to human rights standards that we demand the rest of the world to adhere to. And it's something that ultimately is going to redound very seriously against not only the rights of people in this country, but their safety. This is why there was such worldwide opposition and so much opposition within the U.S. military and Defense Department to the military tribunal order, because they knew that the international system, including international human rights law, depends on a system of reciprocity. And if we are going to subject nationals of another country to military kangaroo courts, then we have no protection for our own members of our own armed services, or for that matter, citizens, when they are tried before military tribunals. So it's a serious problem that's part of a much broader, more serious problem.
Bill Savage, City Club member, related to the secret tribunals, could you comment on the Guantanamo prison and what ACL, is there some way out of that?
Yeah, that is something where we have not been particularly active because it's being handled so well by our colleagues in the international human rights community. Since I've had to debate that issue, and I guess I will again on the Today Show next week against Alan Dershowitz, there are these liberals who have been taking a position, sort of a contrarian position. I have familiarized myself a bit with the international standards and conventions, and even the Bush administration, after a lot of pressure from the public, acknowledged that at the very least these individuals are entitled to basic humanitarian standards. The rub, of course, is that they're not going to be recognized as prisoners of war and that they will be subject to indefinite detention. It's the very same problem that we're facing with respect to the so-called detainees in this country, which in some ways is even more shocking because you're talking, at least in the, and I am not at all an apologist for deviating from the international standards, getting back to the previous question that we have to honor in that situation. But these were people who were captured on the field of battle in combat, not American citizens, as opposed to, in this country, we're talking about peaceful, law-abiding citizens who are being subjected to the same inhumane treatment with a same denial of due process.
Meng Zhou, City Club member and former Constitution team member. And my question to you is, what do you think is our duty as young people to ensure the protection of our civil liberties? And what do you think we can do, even though many of us aren't old enough to vote, what do you think we should do to make sure that our constitutional rights aren't violated?
You certainly have the right to speak, even though you don't have the right to vote. And it's one of the great things about the internet and email. It makes it so easy.